Thank you very much, and thank you all for coming. I will just briefly add a few sentences about my co-speakers today, Kevin and Dejan. Kevin is a multidisciplinary lawyer who is practicing corporate commercial law, but he is also a specialist in some specific industries like healthcare and nowadays AI. He was involved actually in AI regulations even before AI Act in EU was adopted, and some of regulations enshrined in AI Act have not even started to be implemented. Kevin is also, as his title, a partner in Ketler and Partners law firm, which is a member of Karanovic and Partners law firm. And today we have a special honor to have with us industry expert Dejan Radic. He has 10 years of experience in programming in Web3, but he also wants to take the opportunity to speak with us today about regulations and about new challenges in regard of implementing AI in something that I would say is based on another principles or at least different principles as those enshrined in AI systems and models. So thank you both. And I would like to briefly just outline what we will be talking about today. We will be talking about how AI is changing or could change protocols and different Web3 applications, but also we will talk about how this could be regarded from regulation perspective. And to start with, I would like to ask Dejan just to outline us your experience, what you faced, what are the challenges nowadays, what you are thinking about, when it comes to future of programming, and what are the costs and benefits of implementing AI, and especially kindly explain to us the level of autonomy of AI solution that is feasible in Web3 paradigm.
First of all, thank you for the warm introduction. When we see our today's topic, basically, it's focusing on the level of autonomy, as Aleksandra has mentioned. And right now, we're at the verging point of bringing the AI agents towards different kinds of applications. Governance is one of them. Now, in the case of AI agent making decisions in front of the audience of people, basically it's similar as if we have a single person making different kinds of decisions. So right now, systems that are being built are usually built by utilizing the concepts known as human in the loop. So definitely, right now we are not going towards fully autonomous systems, and we are focusing on bringing humans to derive the set of decisions made by the agents. But usually, when we talk about any kind of AI solution, we know that AI is as good as the data that is behind it. So usually, we would tend to clarify the way how the system was trained, what the data was used to actually train it, and then the information we provide on the level of prompt engineering, the core information that the AI agents at the end of the day are going to use. Basically, those are the most important points. And so far, with the hallucinations and unclarities regarding the outputs of the systems, basically, we are still working on amplifying the accuracy, but human in the loop is still something that we need to take care of. So usually, in today's systems, it's about control of the human. And it's about augmenting the human to make better decisions. And as we evolve, we are going to have fully autonomous AI agents. And when we look at the title of today's talk, basically combining the Web3 aspects of the DAOs on one side and AI agents on the other, the A in DAO is autonomous, and the AI agent is basically an autonomous entity that acts on behalf of itself, I would say. So autonomous operations of the exact system is something we are thriving for, but now it opens up a lot of questions that you guys are going to answer on the regulatory aspect, also the moral dilemma of all of it, but basically that would be kind of introduction.
Yeah, but just one additional question for you. We are now then speaking about implementing certain AI solutions. I'm not talking about technology itself, whether it will be machine learning or something else, but we are not in a position yet to speak about fully autonomous AI agent, AI solution model that will be implemented in the protocol. And Kevin will speak about whether it is feasible from the perspective of regulations and in which manner. But even from technology perspective, if we have hallucinations nowadays, even when we use some language model, like I will not mention names because we all know them, then we cannot speak about some autonomous systems that will govern the whole protocols, money, funds, and more important stuff than, for example, answering our daily questions.
Well, this is a good point, and so far we are not on the level of that, definitely. We are at a level where these models are doing really good summarization of a lot of inputs. And like the level of explainability also depends on the way how model was actually developed and of course on prompt engineering side. How are we going to ask questions and what kind of additional underlying data we are going to provide to the system to give better outputs. So yes, it's still augmentation and not full autonomy, but as we move forward, it will be more and more autonomous.
Thank you very much. So I actually now wondering, could we regulate AI usages if we are still not aware of their capacity? Kevin is here to speak about, I would say, huge portion of new legislation in EU, very complex in principle. And please, could you provide us just an overview of the solutions of the principles that are part of the regulation and your thinking in regard to what Dan just mentioned? You know, we do not have still sufficient level of development in IT sector, but we are regulating it maybe even towards coercion of some specific activities.
Thank you, Aleksandra. Also, big hello from my end. Coming today from Slovenia, it's very interesting to meet all these people here and speaking about different topics. And one of the things is very, very, let's say, good for us coming from a bit more regulated part of the world in terms of new technologies and stuff like that, is that you get new perspectives. And one of the main detriments in the European Union, according to some people also from the industry, is the fact that maybe we are coming too strong in regulation of different aspects of technologies, which we as lawyers definitely not know. Things that are being spoken here and to which I'm very glad to listen and have the ability to listen to those is still very complicated for me, I must admit. And this has been the same thing for those people preparing the legislation as well. Aleksandra did mention that I had the ability to participate in these initial discussions. Please don't blame me for any provisions that are in, because I was not part of the initial, or let's say the narrowest of the working groups. But I did have the chance to listen to some discussions that were at that stage. And differently than some perceptions, the true intent behind the European Union going so strong into regulation was to try to enlarge or to improve people's trust in new technology. Because people's trust in such technologies would increase the use of such technologies, And the increased use would definitely have positive impacts on our GDP. New working spaces, new technologies, providing some additional turnover in that capacity. So when we are all listening to what was the core ambit of the European Union in going so strong in this regulation, we can definitely conclude that they did have some good intentions. Paired, of course, with the fact that everything in the European Union, from the GDPR onwards, deals with fundamental rights of people. So European Union, when they introduce new developments, they always go from that perspective. So how we can protect fundamental rights. We started with privacy and the GDPR. Apparently this was not enough because they soon learned that GDPR as such could be a bit, let's say, too far behind when it comes to technology aspects. So they introduced something which was one of the largest currently exporting factors in terms of new legislation, and that is the AI Act. The European Union was definitely the first with such a comprehensive legal piece. Some other examples already did exist, but still. And with AI Act being brought forward to all the member states as a regulation, meaning that each and every country must directly use that text without any local, let's say, German acts, laws, Slovenian laws, Croatian laws, etc. This means that they wanted to harmonize the entire legal sphere of the AI regulation. One big problem, and this was just the discussion before we came to the floor, is that it's vague. If you read AI Act, you don't learn too much, right? You learn about the basic nice words such as fundamental rights, risk approach, the structure of different risks and level of risks. But you don't actually learn about which tool, for example, is actually being regulated. You don't learn directly what you need specifically to do, because you have a lot of different words, meaning that is appropriate, that is relevant, all these adjectives that you need to somehow, in the end, translate to a language which is far more objective and far more specific than the legal language, right? And if we just briefly see what the ambit of the AI Act is that they introduce a pyramid structure. And the AI Act provides for different obligations on different levels of the pyramid. Majority of things, which are at the bottom of the pyramid, would definitely fall outside the scope of application. So majority of AI systems would definitely not be governed by the AI Act. This is for a fact. Some statistics even say that probably around 55 to 60% of available AI systems or systems that could be available in the near future will fall outside the scope of regulation of the AI Act. So what we are then discussing? We are discussing the higher levels of the pyramid. The next one, so-called limited or minimum risks, which require only transparency obligations, in which you would need to tell someone, okay, this is being generated by AI, this is being, you will need to tag, you will need to provide different transparency information. This is one level. The next one, which is narrower, are the things that are most highly regulated under the AI Act, and this is the high-risk systems. Half of the entire AI Act deals with high-risk AI systems. What are those? It depends. This is a very usual thing a lawyer would say. On one part, you have falling under the high risk everything that already has its designated European legal framework. For example, toys, medicinal products, healthcare devices, machinery, aircraft, stuff like that. So whatever is already regulated separately falls under this category. On the other hand, you also have sector-specific stuff that is also, due to its importance, being classified as a high risk. For example, educational or vocational trainings, healthcare aspects, stuff like that, so industry-wise. And on the top of the pyramid, you have something that is prohibited. And, most importantly, differently than in other parts of the AI Act, you don't have that the provider cannot put on the market or the deployer cannot use certain technology. It's operator indifferent, meaning that certain things just cannot be used. And it doesn't make, and this is very important also from the perspective of DAOs, because there we always tend to ask ourselves, who is the person, or at least lawyers, we tend to ask this question, who is the one who would be liable? Who is the one who would be responsible if something goes wrong, if a decision is not correct, right? And in relation to prohibited practices, this is irrelevant, because certain things, such as, for example, social scoring, if it leads to some unwanted, let's say, minuses or detriments, that you would social score part of the team, part of the population, and you would exclude, for example, in Slovenia, quite common issue, gypsies, for example, right? This is something that would be a prohibited practice under the AI Act. And coming back to DAOs, for example, it doesn't make any difference whether or not this is a developer. This is a person who votes within the system, who concludes a smart contract within the voting system, for example, of a DAO. It doesn't make sense. It doesn't mean anything because it is a prohibited practice regardless of what it is and who should that be. So, in the future, what we will definitely need to pay attention is the question of who wants to provide something to the market of the European Union, for example. And this is not only a problem of the European Union, because you're not being, even if you're a developer, for example, in Serbia, you would still need to fulfill certain obligations if your product would want to be on the European market. That's the main thing. We call it like an extraterritorial scope, similar as the GDPR, for example. It doesn't make sense if Chinese process some data of the Europeans. They are processing the data of Europeans, and they can face certain consequences when it comes to that.
Thank you very much, Ken, for this overview. I just have some, I would say, comments to what you have mentioned. Here in Serbia, we also have some endeavors to regulate AI, and we have AI Act as starting point. And you just mentioned, for example, and Dejan also mentioned that the data is very important. From Dejan's perspective, the data are important because you will have good output if the input, if the training data are of a good quality. From the perspective of AI Act, we have potentially risks, and this is something that is maybe important also to emphasize that AI Act is one of the first regulations in the world that starts from the perspective of risks. It regulates everything from the perspective, what are the risks that we are taking when we are using the new technology. And I would say then that maybe the biggest problem nowadays is not only the fact that we do not have sufficient technology development, which we see how it acts in order to be regulated, but we also do not have sufficient clarity on the world level what should be prohibited, what should be restricted or not. For example, social scoring, you just mentioned social scoring. It is one of the practices that is allowed in some countries. And
for example, if I may interrupt you, for example, the Netherlands, they had a very big system of social scoring implemented. Unfortunately, due to their governmental disruptions and everything, it didn't go through as they wanted. But even governments in the European Union were using it, and will try to continue using it, definitely.
And the second example I would use is also a collection of personal data and especially biometric data. So we have different levels of regulations and prohibitions of using and collecting and processing that data in AI Act. And some scholars and also activists just say that it is a blueprint, that AI Act just becomes a blueprint of how you could collect that data without being in breach of the law. You have prohibited practices, for example, in real-time biometric surveillance, but you also have situations in which you could, for example, in gaming, to follow emotional states of gamers, and it is allowed. So I'm just wondering what will be the consequences also from your Dan perspective, and you, Kevin, from your clients, how people in the industry nowadays thinking about this, what will be prohibited, and how it will change the manner in which they form, create, and develop their protocols. Dan, you could start just briefly. And
well, we've mentioned the data, and basically when we talk about data, we can always find ways to divide the data into separate categories. And in general, when it comes to personal data, basically under GDPR we have defined what kind of data it is, and subsequently what kind of processing we can do on it. In general, when we build these systems, usually developers tend to create it to be versatile. So those systems need to be pretty flexible. They are building it to be maintained, opened, to tackle as much as use cases as possible, to think about the edge cases, to think about the way how these systems would give answers in every possible way, depending on any kind of input. And when you create something to be so wide and holistic, you're always going to open up a lot of questions regarding it. And in general, any kind of input producing any kind of output, it's always a question what kind of input should I ask? Of course, first things that people were asking ChatGPT 3 years ago when it came out were something about crime, something about some moral dilemmas and everything. And then as the time passed, basically they've created means of dealing with these in pre-processing or post-processing of the inputs and so on. And usually many of these use cases came out to be the general orientation. So after a while, when you create a wide system, you're going to make it more narrow and narrow and narrow, and at some point it's going to have a single use case. Internet came too wide, after a while it was too narrow, now it's again too wide. So it also depends on the level of, I would say, the maturity of technology. Maturity of technology is still there. And now, every time when we invent something new, we open up a lot of questions. And when it comes with some kind of alignment with codifying something as laws, for example, people tend to say that in 19th century, laws were in front of the technology, because basically the most educated people were people thinking about the way how to codify the way we behave. But now technology every now and then brings something new out there, and we're thinking of the ways, okay, what can this produce?
And how this technology distorts maybe existing roles in DAOs protocols in terms, we have main contributors, we have front ends that will allow access to a protocol. We have, for example, some service providers that enforce protocol decisions. We have also maybe some company that is behind the protocol, but in which manner AI, and I'm not just speaking about fully autonomous AI, in which manner it is changing these roles. And afterwards, I would like to ask Kevin to just explain how this could be perceived from the roles from AI Act in terms of deployers, providers, how we can know who is who, both from technology perspective and from the perspective of the law.
Well, DAO is a general, as I would say, a living organism, like in general, has a couple of roles, and usually somebody creates it. So there is a creator. Now, this creator can continue to be the part of organization, but it doesn't have to, in general. After that, you have like general members, people who are, like in general terms, stakeholders. So they are interested in this organization, and they can, for example, create proposals. And those proposals can be validated by AI or by other people and so on. So then there is a point of voting, like these members or some other people who are making decisions in front of a board using like weighted voting mechanisms, quadratic voting, however we want to create it. Basically, they do the votes, and then certain proposal is being either accepted or denied. And after that, we go towards implementation of it. Then we have people who work for DAOs, and so far those people, like they're oriented towards like maximizing their value towards the DAO so that they get the benefits out of it, either financial or some other ones. And in general sense, if you work for a DAO that's being governed only by the AI agent, that means you're effectively working for an AI agent. And I was having a discussion also today where I mentioned that when it comes to Google and the way we deal with the content creation, for example, towards SEO optimization, for more than 15 years, we're kind of working for AI algorithms already. For example, if we want to maximize the viewability of our content on Instagram, we're kind of working for AI. So it already exists. Now, okay, like what's the turning point of like, okay, right now we're working for some kind of like more intelligent AI. Okay, right now we have the paper, attention is all you need. We have the biggest use case. We have Gen AI, and now it is different from like machine learning that deals only with numbers. Now we're also dealing with text, which are numbers in behind. But like more layers and more parameters and bigger neural networks means more intelligence. So like, when is the point we have actually started to work for AI as people? And definitely all of us, by producing a single tweet, a single publication on any kind of social media, and if that has been scraped by any kind of company that's training the Gen AI algorithm, we kind of have worked for AI pro bono. So like in general, these are questions which are kind of interesting. But when it comes only to DAOs, like those people who are working, and then also AI that can execute certain tasks, AI that can validate, for example, if proposals are good, are they aligned with some kind of vision and direction and strategy of this particular DAO? Like this kind of alignment can be particularly text-based. And right now, Gen AI is really good with aligning, for example, semantics of two texts. And it can say, like, with 85% probability, this is something that is aligned, so let's continue with this proposal, or not, for example. So there are many ways how AI can contribute, but fully autonomous orientation, like we're not at technological level to fully have it, but in some more narrow use cases, it can be something where we are already kind of there.
Yeah, and it is excellent that you mentioned some specific use cases. And Kevin also mentioned in the first part that we have pyramidal structure. So some use cases are considered to be of a level of a risk that requires further obligations, certain reporting obligations, etc. And I would like to ask Kevin, from the perspective of DAOs, how these specific roles and obligations are regarded from the perspective of AI Act. How can we know who is responsible if we have multiple contributors, voters in the system, and when it is relevant? Sometimes it is not relevant. If we have a paradigm in which we are just voting in a video game, it is fine. But for example, if we have some protocol that will allocate funds to all of to us, and we are part of the huge organization of the protocol, when we are, for example, Dan is a main contributor, you are user, and for example, I am a company that is behind the protocol and makes it available to all of the audience. Who are we in the structure, and how we should comply with the new regulations? And you can change our roles if you are not.
If I'm not comfortable with that. Yeah, no, I will. So the shortest of the answers, if you ask me how do we know, is that we don't. We don't know how the legal regime would apply to situations like this. First of all, the AI Act as such is still not fully applicable, right? It will only be from next year, and even some provisions from 27 onwards. So we still have some time. The things that lawyers definitely like is to describe certain roles. And yes, things that you mentioned, for example, as a user, this is, of course, needs to be put in a legal context, because importantly, AI Act does not deal with private use. So the things that people are using privately or within their families, even small communities, not a problem at all, and the government will have nothing to do with that. The second important part in relation to this is, and I will briefly touch before I go to the roles, the question of data, because one of the main requirements is that you have, in relation to high-risk systems, that you have quality data, right? The inputs need to be good. This is not only relevant for the developers, for users or deployers, as we would say in the legal language. This is also important from the legal perspective, because one of the things that we need to avoid, and which is good to avoid, is data bias, right? And the autonomy in DAOs can sometimes lead also to the situation where you would have with certain centralized structure, which is contrary to the ambit and the goal of a DAO, right, being decentralized. But if you have, for example, only limited functions that would provide certain aspects, if they provide the votes and everything, and the data is being generated through them, this definitely leads to the bias issue, right? Because the ones that will be hurt is the minority, for example, that would be voting, or the majority that would be voting, but excluding the minority, for example. This is one of the issues. So, if we briefly go through the roles, definitely from the legal perspective, we have very easy 5 structures, 5 functions or 5 roles that are relevant in this context. And they usually don't have nothing to do with the DAOs, because as you probably know, DAO as such is not being mentioned in the AI Act. Not even one specific technology or aspect of technology is being mentioned in the AI Act. Contrary to what most people think, AI Act also doesn't deal with models, AI models. No, it doesn't. Only the generative language models, those are being as a model applied in the AI. But AI Act is speaking about AI systems as such, right? And importantly, it is being technology neutral. Why? Because European Union learned this on a very good example in product liability. Everyone knows the American examples, how things went with the product liability structures. When, for example, you bought a bottle of Coke and the bottle exploded in your home, causing damage to you, to your family, etc. Right? So this is a system, the product liability, that is being around from 70s in the European Union. And they learned that if we provide a very vague language, but still have the judges, the authorities that will look at that and that will pair with the technology sector and have discussions with the technology sector, that we can then provide some legal certainty. And legal certainty is something that we all strive for, right? So the Product Liability Directive is, for example, still applicable in the European Union from the 80s onwards. And it hasn't changed, only one change in all those years. And they have the same ambit also with the AI Act. They will try to put it like that. So when we speak of the roles, often it happens that they are something quite contrary to the language that would be used by developers. Something contrary that would be used in the tech language or that would be used in the context of DAOs. But still, we need to provide those. And one of those is the most important, which also has the most obligations, is the developer as such, right? On the second thing, we have the deployer. Deployer being the one who, for the professional ambit, uses these things. And then we also have the representative. If you from Serbia put something in the European Union on the manor, you need to use then the authorized representative in the European Union, which costs money, of course. And then also the distributor and importer. They all have certain roles, and they will all need to take care of certain obligations. They will need to be careful that you have CE marking, for example, in relation to high-risk AI systems that are being deployed on the market and stuff like that. So if I shortly answer who would be liable, probably the AI Act will not tell that. And usually in such contexts, you would either have someone who would put trademark on it. And lawyers in Slovenia or any other country will say, okay, provision of Article 57 of the AI Act provides that someone who attaches its trademark to a system can be held liable for the product as such.
And sorry, Kevin, this is not only from the perspective of AI Act. They will also regard other regulations and try to find who is liable, for example, in regards to consumer protection regulations.
Of course. One big mistake that the tech setup can, or tech community can do, is that you only look to the AI Act. Unfortunately, it will only provide part of the answers, whereas other things such as liability, who is in the end responsible, will lie in each and every country, and unfortunately, often quite differently. Because in Germany, for example, the situation is different than in Slovenia. And we're only in the European Union, right? So, yeah, usually things will be like that, that someone who attaches its name in such things would be held liable. But in the context of DAO, being a lawyer, right, I must also say that each and every one who would participate into such decision or participate into such decision could be held liable, not under AI Act, but under our local legislations. Right?
So I would just say that it will depend that we should start from questioning ourselves, first of all, which is the use case of our algorithm, and then how much we contributed to some autonomous decision-making. As I understood, Dan, we are not there yet to speak about autonomous decisions, but there are systems like Discord servers or Reddit chatbots that are autonomous to a certain extent. But this is not problematic as long as we are not in the territory of, for example, education, medicines, etc. And since we have less than 10 minutes, I would like to start Q&A with one example with my co-speakers. And that is, imagine that we have, for example, some DAO in which contribute not only teachers, but also parents, students, all relevant data, and that DAO has certain level of autonomy decision making. So from the perspective of legislation, whether what are the conditions for this DAO to be operational, whether it could be operational at all if it is classified as high risk. This is for you, Kevin, and for Dejan, if Kevin now says that, you know, we will have some issues with that, do you have some, for example, idea how we can adapt that DAO to be more in line with the regulations in terms of human control, and whether human control distorts then that DAO and reverts back decentralization to central model which is not controlled, or we have some solution in front of us? So Kevin, please.
So we have the educational aspect. So this would most likely put it into the high-risk category in the terms that you described, right? So we would have a full set of obligations under the AI Act that would be applicable to that. Briefly, the need to register in a EU-wide register, the requirement to provide management data systems, to provide the transparency requirements and notification, logs in order to be able to verify the steps. And the third thing, for example, which is contrary to the autonomous system, also human intervention, right? Human oversight, which needs to be conducted in such things. So usually we would be able to put that on the market under those limitations. And this is where the law stops, right? Because the implementation of these things, how to incorporate logs, how to incorporate tags that provide you certain information, how to enable appropriate human control within the systems, this is now for you. I had the easy part.
Well, first of all, as we said, you know, like some kind of control is needed. And in general, if you're teaching something to somebody, you know, like verifiability of that kind of teaching is kind of a thing. So in general, in AI systems, when it comes to like connection towards the Web3, there is a thing called verifiable inference. So first, we need to check if this AI has really done the search of this neural network in depth. So has it provided like the real inference there? That's one of the questions. And how we can do it, basically there are a combination of like crypto-economic and cryptography level implementations with ZK proofs and so on, which are enabling this. Then when we look at the spectrum of like service level orientation, you know, like underlying we have some decentralized physical infrastructure, let's say, you know, like bare metal servers. On top of it, we have a blockchain network of connected components. We have validators, miners, who shouldn't be responsible towards running the DAOs on top of them, because they are crypto-economically liable to provide good proofs and validation of the transactions. So their power is to validate transactions. So when we boil it down to like Roosevelt's, with great power comes great responsibility, their power is limited, so they won't have any responsibility. We go up, somebody who is deploying, okay, we have alignment with like creator of the DAO, deployer of smart contract on top of some layer 2 blockchain that is validating transactions on L1 and providing the ability to do the votes. So we see many roles inside where a lot of these are kind of, but not fully aligned with the ones that you have mentioned that are covered with AI Act. So in general, on top of it, you have like real users and people who have like voting power and everything, and they have the power, so they should have the responsibility. So when we look at it, it's like neatly defined. And right now, if AI is the only place with a centralized model that is giving the output towards the students and telling them, you should learn this in this way, like we have centralized power of the way of giving somebody some information, so we get back to the data and what has it been trained on, and has somebody, while training it, done some kind of filtering of this content to be non-biased, to like remove hate speech, remove
and
some things.
whether that someone has possibility to train that model additionally if it comes up that something is missing. For example, that there are some biased results, especially if we have testing environment and then we have real environment. And in real environment, something occurs, some additional input or factor, which actually gives some opaque result. I would say that from the perspective of AI Act, and we do not have time now to speak about that, it is very important also to use the opportunity of sandboxes and of testing solutions before providing them on the market. And I think that from the perspective of national legislators, especially, for example, for Serbia, which does not have to just transpose all provisions of AI Act by word, it is important to see how that regulators could help their companies in terms of providing them the opportunity to develop solution without too broad administrative costs, and to test that before being obliged to comply with all reporting obligations and other stuff that Kevin mentioned. With this in mind,
to add,
yeah.
to briefly add on this
Of
point,
course.
you will definitely have within the European Union a set of regulatory sandboxes, because each and every member state is obliged to provide for such a regulatory sandbox. Even Slovenia, which until now didn't have anyone, not even one until now. So this will definitely come into practice, and this will also attract foreign developers and projects, because this will not be limited only to the European ones.
I just hope that it will be practicable, feasible, because we have on the European level, we have, for example, for decentralized ledger technologies, some sort of endeavors for implementation of sandboxes, and I think that until last year only, I think Czech authority has submitted application to be part of the sandbox. So even sandboxes should not be regulatory overwhelmed, but let's just leave that for some other panel. I would like to say our audience to ask us if they have any questions, and please, yes.
First of all, thank you for the presentation, for the discussion. My question is to Dan. Dan, you've mentioned that DAOs are often created by, let's say, one person, and then this person kind of withdraws, and the DAO becomes community governed, community driven. So my question, what is the mechanics in detail of how this transition takes place from being, let's say, created by one person, and then shifting from being driven by one person to being driven by a community? And can you also maybe provide some specific examples of Web3 projects where AI agents take part in DAO governance? Thank you.
Well, in general, it boils down to the governance tokens. So somebody would launch a governance token, and in this particular case, basically, you have the option for somebody to put this governance token out there, and somebody can either do some action or buy it and get the voting power. But in general, it's about empowerment by this, let's say, single person or multiple persons actually starting a DAO. There are ways where they think from the standpoint of like creating some vision, and then people are actually who want to participate, contributing to the DAO in some way, and then getting either the voting rights or some other rights within this organization. No, in general, it can be financial incentives or some other incentives. When it comes to companies that are already implementing AI agents, basically inside of the DAO governance, we have Curve, who has participated in it. We have the NEAR Foundation, and we have really good tries on a virtuals protocol to run it in this kind of way. And every one of them are using it from different standpoints. But as DAOs are evolving, and as we are kind of like at the point where there are several ways of conducting the votes, conducting the proposals alignment, conducting the ways how we think of the process in general, different aspects of using AI agents in this kind of context are going to be there. And I think the advantages are going to be the DAOs who are already having enough data and enough alignment of the community so that these agents can actually really help in governing them.
Thank you very much. Do you maybe have some follow-up questions or someone else, some additional question? In that case, I would like to thank once more to my co-speakers, Dejan and Kevin, and please clap your hands for them once more. Thank you.